Albert, it is mentioned subsequently that proof of substantiality of the surety calls for documentary evidence of facts to prove capacity to meet monetary obligations. And court went on to give an example that proof of ownership of property can be attached and sold is that of the proof of evidential value. Your Worship, it is not a joke that we come and stand surety when we cannot afford to forfeit a bond. Also, the two cases, they are distinguished. Both of Mugera John, but different application. 002 of 2022, different application, and 021 of 2023. Both those cases indicate that sureties should have some credible source of income. Surety, Your Worship, Honorable Kiza Winfred, Your Worship, was very ably introduced as the former leader of opposition and former member of parliament. That word, former, Your Worship. Your Worship, no evidence has been adduced to show that she has any credible source of income, or is gainfully employed anywhere, or existence of any assets, Your Worship. That she can be said to have the ability, Your Worship, in the event of any forfeiture of a bond, to pay it comfortably. The third surety, Otieno Joseph.
Land titles and all. And by the way, Your Honor, these guidelines are different from, for example, the guidelines and the anti-corruption division, which provide for what the state is asking for. These are general guidelines for all courts of judicature, and they are specific. Why? Because the nature of the offenses, which are outside, the offenses are under the SCP. The offense the accused is charged with unlawful obtaining or disclosing of personal data. This is not a financial crime. The nature of the sentence that can be imposed is clear in the provision. And therefore, to require very stringent and unreasonable tests for sureties would be to disregard the bail guidelines, would be to disregard the Constitution. The accused person has the right to apply for bail. She exercised the right and applied. The state is trying to fetter that right with many unreasonable requirements that have no foundation, even in the bail guidelines, developed for the judiciary. Your Honor, it is therefore our view that on record, what's important, what's clear is that the sureties are substantial. A managing director of power, surely cannot be someone who will fail to meet obligations. The obligations of sureties, Your Honor, are provided in paragraph 16.
The article of the Constitution say all power belongs to the people. Does it say it belongs to the Constitution? Hey, all power belongs to you, and you are supposed to use it through what? That Constitution, which I personally participated in making right from the beginning to the end, has been today murdered, maimed. When you cripple, it has been crippled, has been shot down, has been injured, has been, I don't know. It is not there anymore. It is there, it is not there anymore. That's why you see, I understand. Have you been reading tweet? Have you been reading? Have you read the tweet of the big son? What has he been tweeting? That we have now finished 22. Those are few, they are embarrassing us. We are in to kill more. Have you read it? So what are you doing now that you've read it? If that one who talks like that cannot be arrested, why do you go to arrest Mwanga Chivumbi, whom I understand they intend to arrest? Have you heard about that? Goodbye.
And the Constitution has failed.
The ruling in this application is deferred to the 28th of January 2026 at 9 a.m. Accused will be remanded till then.
There, they will put you in prison and imprison you and sentence you. But in the meantime, because you are declared innocent until proved guilty, we have the law of applying for bail. And when you apply for bail and your offense is bailable, we have what we call bailable offenses and non-bailable. Sarah's offense is bailable. It is an accusation which is bailable, that he got personal information without permission. The charge is even awkward. It is awkward. And now, when we applied for bail that time, we put surety. We came today knowing that we are going to get Sarah out of on bail. But on listening to now, the state attorney came with very, very nonsensical reasons for objecting to bail. And one major one was that Sarah did not bring distinguished, I don't think she even said credible. He said distinguished rich people. That Sarah did not bring here rich people to stand for her. Because he said, and these sureties were very distinguished. You know, the former member of parliament for 2 terms and former leader of opposition. To be a leader of opposition in parliament is an alternative to speaker. And now that because she's retired now, she's no longer in holding positions like that. She is nobody, she is nothing, she has no money, she cannot stand for bail for Sarah. The other lady she talked about, and this woman is very, I don't know what to say. I don't know why President Museveni has really promoted women in positions to appear useless. You see, this is my problem. Because the state attorney is a woman, the judge, the magistrate is a woman, and they are demeaning distinguished women of caliber and integrity, like Honorable Winnie Chiza, like Her Excellency Edith Sempara, that distinguished woman. When President Museveni had taken over Kampala here and he ruled Uganda, that woman was a very effective ambassador in many countries, in Denmark, Norway, America, where I remember when we were struggling with her to secure this AGOA. We fought for AGOA, this thing of and yet Uganda never benefited from it. But she used to take me to meet the ministers in America. She used to take me to see these big people in America, secure positions for Uganda here for support. And now she's retired back home in her dignified home. I mean, did this state attorney visit these distinguished ladies to see that they are poor and they don't have enough resources to stand security? Can you imagine demeaning such distinguished people? And that is the reason for not giving Sarah bail. And then also the magistrate, her worship. And she says, you go away, I will consider these things within a whole week. I mean, look here. The situation should have been, I have adjourned for afternoon. Let me go and consider the arguments from the prosecutor and from the defense, and in the afternoon I will come with my judgment. But she said, come back on 28th. Can you imagine these girls? I even call them girls. I'm not going to call them my daughters because my daughters are brilliant. They wouldn't do something like that. No, you cannot demean people like that. So for me, what I see, as I have already said, everybody is scared. The woman is, the prosecutor is scared. The magistrate is scared of losing her job or not getting promotion. And therefore, justice in Uganda, where is it? Why should Sarah really be suffering in prison? And I understand, by the way, that many more who were in politics there are about to be arrested and incarcerated. And therefore I end up by saying, you Ugandans, especially you press, you. All you need, all you know is to get the news and go and put it there. What more do you do?
Holding onto a matter and failing to process it. If the judicial officer decides not to grant bail, there are other options. But we need to get to that step as quickly as possible. That is all we have been trying to impress on the court. And yes, we shall continue to explore other options, and also to point out to the court that the management of this matter is seriously undermining public confidence in the ability of courts of law to be impartial. And this is dangerous for the judiciary as well. So we hope reason will prevail.